about to begin. If you haven't already, please be sure to silence any electronic devices. Thank you. Okay. Yes, it is. All right, I'll call again in 2 minutes. All right. All right. All right, we'll be ready. Thank you. Appeals, Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is the time set for oral argument in Embry versus Burroughs Concrete. Our case number is CV130427. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time if you wish to do so. Now, if you wish to do so, you need to keep track of your own time. There is a digital clock right at the podium, so make sure you account for that. Out of respect for counsel, I would ask that those in attendance turn their cell phones off or on vibrate. We have read the briefs. We've conferenced the case this morning. We encourage you to keep that in mind as you present oral argument. Also, our proceedings are being recorded and will be posted to YouTube in due course. As you begin your argument, please state your name and the parties that you or parties that you represent. With that, let's first hear from counsel for Mr. Luce.
Thank you, Your Honor.
If it please the court, Don Luce on behalf of the appellants Darrell Embry and Richard Silva. My associate Jesse Callahan is in attendance as well. I am going to reserve 5 minutes for rebuttal. In acknowledgement of the fact that the court has read the briefs, I'd like to take just a brief opportunity to recite what I believe are the material facts regarding the two issues which are the subject of our appeal, which of course is the application of the economic loss doctrine and whether or not a cause of action may be pursued for implied warranty. So this case involves the purchase of a new home which was constructed by Loma Vista and Burroughs as well as other subcontractors. Darrell and Richard are the original purchasers of the property, and Loma Vista and Burroughs were the original contractors. After the new home was constructed and occupied for a period of years...
Let me ask you, Loma Vista or Burroughs was a contractor or a subcontractor?
Subcontractor.
Thank you.
I'm sorry, Your Honor.
And it was a new home, not a big remodel where they go in and tear out the inside of the old home and make a new one.
Correct. Brand new
I don't know if it makes
construction.
any difference. I just wanted to make
Brand new
sure I was,
construction.
properly oriented.
We understand from the information provided by Loma Vista and Burroughs, and which is a part of the record below, that they had a contract between themselves. We believe that that contract provided that Burroughs would provide contract work on the project in exchange for a specified sum. We were not a party to that contract. Our contract in this case was with Loma Vista, the original builder and the vendor of the property.
So where is Loma Vista in all of this?
Well, that's an interesting point. Loma Vista, for lack of a better term, has been MIA. They have been between lawyers in the underlying litigation. Application for default has been filed. They hired a lawyer. Another application for default is pending. But the record does suggest that there is a stipulation between Loma Vista and Burroughs that Loma Vista will not pursue any of its claims against Burroughs.
So they are defendant, they're just not part of this appeal. Fair?
Correct. That's correct. Now, this appeal started when the trial court entered an order granting two motions filed by Burroughs. Burroughs filed a motion first claiming that the negligence claim was barred by the ELD. And in support of that argument, they cited to the contract between Loma Vista and Burroughs, because of course there is no contract between the claimants and Burroughs. And on the implied warranty claim, Burroughs argued that because there was no contract between claimants and Burroughs, there was no ability to maintain an implied warranty claim. And the trial judge agreed primarily with Burroughs' arguments. Interestingly, the trial court bifurcated the damages claims on the negligence theory. saying that the ELD precludes claimants from pursuing a negligence claim for damage to the structure, which was the primary damage in this case.
As I recall, there are about 3 or 4 direct quotes in Flagstaff Affordable that run counter to that ruling.
Sullivan as well, Your Honor, I believe. But the trial court.
Did the trial court explain how we could bifurcate under the bifurcate? Or
No.
Or perhaps counsel on the other side will explain that to us.
So the interesting procedural posture at the trial level is that Burroughs is permitted to pursue claims for personal injury. Claimants are permitted to pursue claims for personal injury and damage to any personal property. But with regard to the main claim, which is the damage to the house, the trial court has ruled that that is precluded by the ELD. At the time that those arguments were made, Sullivan was a new case out of the Court of Appeals. Since then, of course, Sullivan has been reworked in some respects by the Supreme Court, but
They vacated about 8 paragraphs. But who's counting?
I understand. And I thought Sullivan was a very well-written decision by the Court of Appeals.
So did I, and bless you.
But if I might be permitted this one small indulgence, because I think we can end the ELD discussion with an examination of some of the direct language out of Sullivan from the Supreme Court. The court there said that in Arizona, the doctrine bars only the recovery of pecuniary or commercial damage, including any decreased value or repair cost for a product or property that is itself the subject of a contract between the plaintiff and defendant, and consequential damages such as lost profits. We decline to extend the doctrine to non-contracting parties. And the court goes on to say that Arizona's economic loss doctrine serves to encourage the private ordering of economic relationships, protect the expectations of contracting parties, ensure the adequacy of contractual remedies, and promote accident deterrence and loss spreading. Okay, and I get that. That is a rationale that I've seen in the progeny of cases leading up to Sullivan. But in this case, the problem is that the claimants in Burroughs never had that opportunity to order their remedies because there was no contract, of course. And with due respect to the trial court, I think the trial court just got it wrong when the trial court said that because there was a contract, being the one between Loma Vista and Burroughs, the economic loss doctrine applies, and therefore there is no claim in negligence with respect to the primary damages. The position that Burroughs is advocating would effectively result in no remedy for the claimants. Assuming that Loma Vista...
What remedy do you think you ought to get under Arizona law, the tort claims or the breach of implied warranty claims?
Both, Your Honor. And I'll explain why in a second.
We need to get to the breach of implied warranty here this morning, too.
I understand. If Burroughs' position were adopted, the claimants would be precluded from suing Burroughs for negligence because there was, quote, a contract between Loma Vista and Burroughs.
Well, and the contract between your clients and Loma Vista.
But exactly. So which one the trial court chose to adopt is still a mystery. The trial court chose to adopt the contract between Loma Vista and Burroughs, not between us and Loma Vista.
There's sort of a line of privity there. It's 2 lines.
It's 2 impermissible lines. But again, remember as well that the damages here involve personal injury as well as personal property. And the cases that we've cited make it clear that unless you have, to use the quote, purely economic loss, the economic loss doctrine doesn't preclude a negligence claim. To the point of the implied warranty. Since the filing of the briefs in this case, Division 2 has had an opportunity to consider a case by homeowners against subcontractors. And Division 2 in Yanni, which came out in November, declined to extend the implied warranty claim to subcontractors, finding that Arizona law does not permit a claim to go against a subcontractor with whom the owners have no contractual relationship, saying that Lofts was narrowly construed and that the Supreme Court in Lofts cautiously created a narrow exception.
Well, Richards and Lofts were based to some extent, or perhaps a large extent, on this idea that we're going to protect the consumer against a big multiple number vendor builder, and then Lofts said, well, you don't have to be the vendor either.
I understand, and I think as well.
But that doesn't come to your aid here, does it?
No, but we don't need that part of it, because I believe Lofts really stands for the proposition that because construction is such an intertwined industry, that the homeowner, the consumer, needs protection when a contractor, and I'll be the first to admit, I haven't found any case in Arizona that expands the definition of contractor to a subcontractor, but I see no reason for the distinction. They're both licensed by the Arizona Register of Contractors. They're both subject to the restrictions in Title 32 and so forth. But I think what Lofts and Richards say, and Donnelly for that matter, is that the people who undertake to build homes in Arizona have to do so in such a manner that they follow industry standards. And if they don't, then the homeowner, regardless of whether they have privity of contract or not, has a claim for the implied warranty. I believe that's what those cases say.
But houses have been built in Arizona for a long, long time, and there's no case acknowledging that type of cause of action. In fact, and your briefs are quite candid, and I appreciate that you found at that point no case. And since that time, Yanni said no. So you're, from my perspective, kind of swimming upstream on that, just because there's no, that fact pattern happens a lot, and there's no case acknowledging. And by that fact pattern, I mean that someone claims a sub did something wrong.
I agree.
And there's no appellate court decision authorizing a claim on these implied warranties in that context in the history of the state.
I agree.
And I don't think there were, from my quick Westlaw this morning, I don't think there was a petition for review in Yanni. So somebody may have a chance to take that up one of these days.
Our research indicates the opposite, Your Honor. I think a petition for review was filed.
Well, that means they must have denied it, and unless are you thinking it's still pending? Maybe it's still pending.
And there is an answer to that, but fair.
I don't know what the answer is, but
right.
Their denial is technically not supposed to mean anything, as they've told us.
So I read Yanni several times to try to figure out why the court reached the conclusion that it did. And what struck me about Yanni was the narrow interpretation that Lonnie gave to Lofts. In fact, the court, I believe, used the word cautiously and narrowly in describing the Lofts decision, as though there were very fine carve-out lines made in the Lofts case. And I didn't read Lofts that restrictively at all. And in fact, in Lofts, at paragraph 9, the Supreme Court cites Columbia Western and says, quote, a contractor impliedly warrants that the construction he undertakes, which ultimately becomes realty, will be performed in a good and workmanlike manner. I read Lofts just the opposite. I think Lofts stands for the proposition that you don't need privity of contract if you're a homeowner and a contractor has failed to perform the work in a good and workmanlike manner. I think you have a cause of action.
And when you're saying contractor, you're including subcontractors.
Yes, Your Honor. And for the life of me, I can't figure out why there would be a distinction other than perhaps that more people in the chain would be subject to claims for unworkmanlike conduct. But I don't think that that's a good policy reason to restrict the application of Lofts to just general contractors. And the court doesn't say that. I'm unaware of any case in Arizona where the court says that the implied warranty claim is limited only to general contractors. Now, the cases we have do involve general contractors, and Yanni refused to extend it to a subcontractor. That's what the status of the law is.
The non-privity implied warranty claim has always been limited to contractors.
Well, since you brought it up, Your Honor, in North Peak,
Yes.
which involved, of course, a design
A
professional.
different kind of warranty, I think.
It is,
Although
but
it's,
but
I think
interestingly,
it's a cousin. I don't think it's completely unrelated. but-
at paragraph 20 of that decision, this court said that there are substantial similarities
Yes.
between the implied warranty described in Donnelly
Ouch.
and the implied warranty of habitability and workmanlike performance addressed in Lofton Woodward.
In North Peak, though, there is no homeowner who is a
Correct.
claimant.
That's correct. It was a general contractor versus an architect.
Who relies on architect's plans. right?
Yes. Unless there are additional questions, Your Honors, I'm going to reserve the remainder of my time for rebuttal.
Very well, thank you, counsel. Ms. Ray, am I pronouncing that name correctly? Rye.
Yes.
Very well, thank you.
May it please the court, Rena Rye for Burroughs Concrete LLC. Jack Barone is also with me, from Ryan Barone as well. With the court's indulgence, I'd like to start with the implied warranty arguments that were raised. We know from decisions like Columbia Western, Woodward, and the lofts at Fillmore that the implied warranty doctrine applies to the construction of new homes. We know that that cause of action sounds in contract, and we know that only parties or privies to the contract can assert the claim. That is the law. In order for the appellants to prevail today, they need to find some sort of exception in our case history allowing for the claim against the subcontractor without privity.
Are they a privy? I don't really like that word,
Right.
actually, but, I mean, there is a line of contractual privity that goes from the claimants to Loma Vista, and then from Loma Vista, there's another line.
I would argue that they are not privy because if we can get into this now or later, but the public policy considerations found in the case history and in the restatement and in the Sullivan decision really talk about the complex web of contracts that are entered into between material suppliers, subcontractors, and builders in a construction context. In the case of the architect or a design professional, you don't have that web of contracts. So, for example, our restatement of torts suggests that we don't upset or just disturb that web of contracts, and that necessarily happens when you allow tort claims to be asserted or direct claims to be asserted by owners against subcontractors with whom the homeowners did not directly contract with.
Or implied warranty claims that really ought to be called torts.
Right.
But we don't call them that, and we say they sound in contract.
Right.
Let me follow up on Judge Gimmel's question. Without regard to policy at this point, but the Yanni language only, and it's quoting lofts, only parties and privies to a contract. What does privies mean?
I would suggest that it is a showing that there's an arm's length negotiation and contractual relationship between the parties, at bar. So,
And I understand that, but they use the word parties and privies to a contract, so they're using privies to mean something different than parties
yes.
to a contract.
And we see sometimes in these construction cases, actually, where the documents specify other individuals that will be privies to the contract or parties to the contract or be conferred with third-party beneficiary status of contracts. And so it's not necessarily that the two parties that sign the contract are the only parties, but in certain cases we've seen in our construction cases that an owner or another individual, an architect or any other person could be named as a intended third-party beneficiary to that contract.
So that's when we're talking about privies and recognizing Arizona has a comparatively restrictive third-party beneficiary rule, that's your understanding of what that
Would be,
means.
yes, and I think that as a part of that argument, there is an understanding when the parties are entering into these contracts that those relationships are being extended. That is not the case in the case at bar.
Might a privy include a sort of an affiliated party that's not really, it has some, for example, well, I don't have an example, but some affiliated party that is not an arm's length contractor in the overall scheme of things.
We also see language saying that, company, ABC Corporation, its parent, subsidiary, affiliates, so on and so forth, are entering into this contract where one party is doing it, but there is an argument that other parties were contemplated
Those may
as
be
privies.
Yeah.
Yeah, so going on, we see that there's been two occasions where the Supreme Court has allowed an exception, allowing an implied warranty claim without privity of contract. In both of those cases, what the Supreme Court sought to do was to protect purchasers of residential construction against the builder. And keep in mind, the builder's not the same as the subcontractor. The builder is the party that's responsible for the overall construction of the structure. For example, I represent subcontractors that do the exterior walls that don't have nothing to do with the structure. Landscapers are subcontractors in these cases, and boroughs poured the concrete. And so it makes sense that when we're talking about protecting homeowners' rights to be able to get redress from the party that was supposed to deliver them their final product, that it be limited to developers, general contractors, and the like. And that's why I believe that the line of cases referred to, which is the Richards case and also the Lofts case, really did narrowly accept from the general rule those circumstances where those protections were needed.
I do recall that, in our Court of Appeals opinion in Hayden, we attempted to limit Richards, and Lofts came along and said, no, Hayden's wrong.
Yes.
So it's got sort of a broadening.
In Hayden is a commercial. In the
maybe
commercial.
We're just one step away from broadening out to include this claim here.
Well, I think that in Hayden, because that was a commercial context, the public policy concerns about protecting residential, innocent, naive purchasers of realty did not exist in the Hayden court.
As I recall, that's what the Court of Appeals thought,
Yeah.
but the Supreme Court in Lofts expressly disapproved that opinion.
Yeah. Well, the two cases that talk about it making these exceptions really do limit it to people that are responsible for the overall construction. In Lofts, the scenario was, as we see in the climate today, where a developer entity is created, and then there's a builder entity, and the developer is the one that sells the property and or is the vendor. And the thought in Lofts was, we don't want to prevent, or we don't want to create a situation where builders get savvy. They construct these arrangements such that they avoid liability to the end user. That's what it did. Now, in Yanni, the Division 2 was faced with this exact scenario. And in Yanni, what the court said was those public policy considerations are not apparent here because the homeowners are not, because of the subcontractors not warranting the habitability of the structure. And that's an important distinction. And the reason why that claim should not lie is because it would disrupt the order of the contractual relationships in the case. The better rule is to allow a homeowner redress through their builder and allow that builder to seek indemnification through its contractual relationships with those subcontractors it believes is responsible vis-a-vis the indemnity arrangements between the contracts. And that's really how this case was postured because Loma Vista did assert a third-party claim against us, and then when we filed a summary judgment motion, decided to dismiss it. So
The point you just made about whether a subcontractor should be held to any kind of implied warranty of habitability or good workmanship is a point that interests me, but couldn't it be said in response that the subcontractor won't be held to the same as the general contractor or developer's implied warranty, but the subcontractor will simply be held to an implied warranty on what that subcontractor has done?
Well, but then you get into this web of contracts because subcontractors work is on top of one another. So then you have the situation where Burroughs Concrete would say, look, we believe that some other entity poked the hole in the
But
sewage pipe, and
I mean, that's what you have when the generals bring in the indemnity claims against all the subs. You have all that.
correct, but we are answering to the general contractor. And so a jury or finder of fact will sort that out through the various contractual relationships. If we allow the direct claim to be asserted, then a jury is going to be asked to potentially provide recourse or a judgment against the subcontractor for an implied warranty, and also expose that subcontractor to another judgment that's brought by the developer for his indemnity obligations. And that's why I believe the restatement and the case law seems to suggest that that we need to maintain the order of these contracts, and that gets disrupted when we start allowing direct claims from owners against subcontractors in construction defect settings in particular. I believe that the Yanni court got it correct, and I believe so too did the trial court, and we would ask that this court affirm the lower court's dismissal of the implied warranty claim as not being recognized as a viable cause of action in Arizona. Then we get to the next real discussion point, which is, can the appellants bring a tort claim? And a lot was going on when this case was in the lower court, because Sullivan was at this court and then at the Supreme Court. And the lower court didn't have the benefit of the Supreme Court decision when she made her rulings in this case. So what's
In Sullivan.
in Sullivan. So it's worthwhile to look at what the lower court did and back it into the Sullivan case and the restatement cited by Sullivan to ascertain whether or not in net effect did the judge get it correct. And I think the answer is yes. It's important to talk about some distinguishing characteristics between Sullivan and our case, and we point that out in our briefs, namely that this is an original purchaser, not a subsequent purchaser. And the reason why that's important, and I think Judge Gemmel, you focused in on the fact that the lack of an opportunity of the homeowner to specifically negotiate remedies for construction defect cases was a central theme in that Sullivan case, and was,
That's why I thought it was in Justice Bale's Flagstaff Affordable.
Right. So I understand that it was important then. I agree it was important, and it's important now. Because in our case, the Embry's had the opportunity to negotiate their remedies and could have done them in a number of ways. They could have asked for direct contracts with the subcontractors. They could have asked to be third-party beneficiaries.
But they didn't have that opportunity with Burroughs.
No, they didn't.
At least not directly.
Not direct unless they asked for it. They could have said, I want to enter the contracts directly with the subcontractors. That's been done. I want the subcontractors to sign something saying that, they're going to live by these same standards and we can sue them directly. That private ordering, that spreading of loss, the opportunity to do that was present in this case.
Counsel, let me ask you, that implies that if they did that, that the economic loss doctrine would or would not apply in that context. Let's say they did all those things.
And did not preserve, in your question, Judge Thomas, preserve tort remedies?
Take it either way.
Yeah. The economic loss doctrine would apply if there was.
Because they're treated as what? Because they're not in privity.
Well, depending on the nature of the arrangement, they could be in privity and get direct contracts with the builders, or they could be privies.
Third-party beneficiary, let me ask another sort of series of questions. Are
Okay.
you aware of any published Arizona appellate decision holding that a third-party beneficiary to a contract is barred, tort claims are barred by the economic loss rule?
I'm not aware of that specific holding.
Are you aware of any, and I can think of one, which is Karsten's, but are you aware of any published appellate decisions in Arizona applying the economic loss doctrine to someone who is not in privity with the defendant?
The economic, well, I can think of cases such as Sullivan, and I can think of the restatement that essentially provides for that effect, because
Sullivan didn't hold that.
well, I know what Sullivan did at the Supreme Court level is suggest that the fact that this individual owner didn't have an opportunity to negotiate claims meant that the defense could not raise as a bar to a tort claim that no tort claims could be made. The court said tort claims would be allowable, but you need to go look at the substantive law of your state to ascertain whether the types of damages that are sought under that tort claim would be supported by law. And in doing that, the Supreme Court suggested to look to the restatement of torts. When you look at the restatement of torts, the restatement of torts makes it clear that these types of economic losses, even in the case of Sullivan, of a subsequent purchaser, could not be brought in tort. In fact, there's a portion of the restatement third of torts that explains this exact scenario and suggests that in a situation where a subcontractor's work is called into question, that a non-privy owner cannot bring a claim for tort damages for purely economic losses.
Is that the draft third
It is.
economic? Okay, but
Yeah.
that's a draft restatement, first of all, and has not been adopted
Right.
in Arizona.
But your point, if I'm following, and it's very interesting to me, your point is to argue that your situation here, this situation is different from Sullivan. Mr. and Mrs. Sullivan, were a subsequent purchaser some years after Pulte sold the homes to the first owner. They did not have any opportunity to negotiate with Pulte. And
Correct.
so we said, and the Supreme Court said, the doctrine doesn't apply to defeat their tort claims.
Mm-hmm.
Maybe there are other things that may defeat their tort claims, but not the economic loss doctrine. But here, the point you're arguing, correct me if I'm wrong, is that the claimants here had an opportunity to negotiate, if they had chosen to do so, directly with Burroughs, or to negotiate with Loma Vista, and through Loma Vista with Burroughs in some fashion.
Right.
Am I following you?
Yes, and the point of that is to hold the parties to the contracts and the remedies that they chose and were acceptable to them when they entered these contracts for the construction of the home.
Yeah, and it does seem to me that the Supreme Court has emphasized the importance of looking to what the parties have done and could have done in their contracting.
Yeah, and also the Supreme Court suggests to look at the substantive law of the state to ascertain and not to bar the tort claim simply because of the economic loss rule. But if you look at what our trial court did, that is what she did. What the trial court did in this case is she didn't preclude the tort claim. She said that portion of the damages that you're seeking that are economic in nature, you need to seek through the party that you contracted with for the contractual remedies that you contracted with and negotiated, which is with Loma Vista. But to also seek those same damages in tort against Burroughs Concrete was not allowable. And then the court's minute entry she used, you can't also get those damages from Burroughs. That,
Okay, so
yes.
just so I understand, in your view, it's not allowable because the homeowner could have insisted on negotiating with Burroughs directly and chose not to?
That is certainly one point. The other point is just because again, restatement, and I understand it's in draft form, but the restatement suggests that the classification of the damages, we need to look at those and ascertain where those damages should be sought. If you allow cost of repair, consequential pecuniary damages in a tort claim against the subcontractor, I can't imagine what that does to construction defect law and how that case gets processed. You will then be asking a jury to award against Burroughs $35,000 in tort damages while simultaneously asking the jury to award $35,000 against Loma Vista. as contract damages, to which there would be no set-off. And that, I think, was what the trial court was getting to here, is you can't double recover, and you can't seek these damages against both of these parties, and you can't seek some of them, in, the same damages in tort and contract. In this case, the nature of the relationships was such that you have an adequate remedy. You can sue Loma Vista
But
for
that's-
breach of the implied warranties, and you have.
That's not exactly what the economic loss doctrine says, though, isn't it? I mean, because the economic loss doctrine, I think, in theory, could apply if, for example, a contract claim was time barred. In other words, there'd be no remedy. So it's not an election of remedies doctrine, is it?
No, it's not. But it does. The reason for my argument is sort of to illustrate what happens if the appellant's argument prevails in this case, which is to lead to the result that two parties are being sued for the cost to repair construction defects simultaneously in the same action, both under tort and contract, and that the jury or fact finder could award damages under both, which I would assume then we would have a difficulty there, because it would allow for the plaintiffs to recover twice for their economic losses.
And if that
I
were to
think
happen,
that's-
you'd have something to say to the trial court, I assume.
Right, but you know, those are that's why it gets complicated, and the trial court says, sue your builder. Your builder can sue the appropriate parties for indemnification, and we can make sure that the order that the restatement draft seeks to protect holds true. And I think, I think I'm out of time, so I'll sit, but I do think that it's important to not disrupt the public policy considerations for keeping the order of contracts together. And I think the restatement suggests that the way that the courts are set up now, that allow for the claims to be brought by the builder and then subsequently the subcontractors, should be the law in Arizona. Thank you.
Counsel. Mr. Luce.
Before we start the clock, I believe I have found that there is a Yanni petition for review. So, it I guess hasn't been acted on yet.
Thank you, Your Honor.
Thanks. Counsel.
I think it's important to remember in this discussion that the basis for the court's granting of the motion was because the court found specifically that the claim was barred by the economic loss doctrine. The trial court didn't find that the claim would lead to a double recovery. The trial court didn't find that the parties had an opportunity to negotiate. In fact, there's nothing in the record concerning that point. I don't know if the parties had an opportunity to negotiate or not, and I don't think on appeal we can assume that they did. I'm also unaware of any reported Arizona decision which speaks to that issue, that says the economic loss doctrine applies even if there's no contract, but the parties had an opportunity to negotiate. I don't think that is the law in Arizona. With this court's indulgence, I'd like to go back to Yanni for a few minutes.
Your argument is that contracting parties have the opportunity to contract and negotiate.
The contracting parties can
The
set their remedies.
Non-contracting parties usually don't.
That's my argument.
Yeah.
If I might return to Yanni for a brief moment, I have had the opportunity, and with the advent of technology, to look up privies in the Merriam-Webster Google version, and it's a person having a part or interest in any action, matter, or thing.
What interest?
A person having a part or interest in any action, matter, or thing. Now, I have to confess, and I believe honesty is the best policy here, I don't know why the word privies was used in this decision, but nonetheless, that is the definition. One of the things that struck me about Yanni when I was reading it and rereading it to try to figure out what the court's rationale might have been was that the court said, nothing in this precision precludes Yanni, and this is at paragraph 13, from pursuing relief for any deficiencies in subcontractors' work. As noted by our Supreme Court in Lofts, a party who is not permitted to bring an implied warranty cause of action against a subcontractor still may sue a developer, general contractor, or vendor who may then seek indemnity from other responsible parties or assign its claim to the plaintiff. Well, I have to suppose that that was kind of important to the court, otherwise the court wouldn't have spent an entire paragraph talking about the ability of a homeowner to pursue other remedies. In this case, however, the record shows that Loma Vista, pursuant to stipulation, has agreed that it's not going to pursue any claims for indemnity against Burroughs, and certainly has no incentive to assign any claims in light of that stipulation to the plaintiffs. So it seems to me that one of the primary bases for the Yanni decision was that the court assumed that the homeowner had other recourse. But in our case, the facts suggest that that doesn't exist. That if the claim is not permitted, then our homeowner has no recourse. And as I mentioned earlier, I don't think that the state of Arizona law, as it now is after Sullivan, precludes our homeowners from pursuing the subcontractors for both negligence and implied warranty for the defects that are attributable solely to Burroughs. These are, and one last thing, and then I'll sit down unless there are questions. I noticed the dialogue concerned, quote, purely economic losses. That apparently that's in the draft of the restatement, and I've seen that phrase used in the reported decisions when the economic loss doctrine is applied. Purely, I think we can all agree, means only. And in this case, it's undisputed that there are other types of damages, including personal injury and personal property. So,
Although the trial court allowed those to go forward, correct?
yes. Is there anything else, Your Honors?
What's the status of that? Is the trial court proceeding pretty much on hold?
The trial court has stayed its proceedings pending this court's ruling.
Thank you.
Thank you.
Thank you.
Counsel, thank you for your presentation. Thank you for your briefs. We appreciate them all. We'll take this matter under advisement. We'll issue a written decision in due course. Thank you.
I thought we had 1:08 left yet, so yeah, I'm not ready. Thank you.
Thank you. Okay, good luck. We'll see you soon. That was a great argument.